Are affidavit of heirship rules different in each state? Have you ever wondered how the rules around an affidavit of heirship can change from one state to another? This question is essential for anyone involved in estate planning or navigating the probate process. An affidavit of heirship is a legal document that helps identify heirs when someone passes away without a will. However, the way this document is used and its requirements can vary significantly depending on where you live. In many states, an affidavit of heirship is a tool to avoid the lengthy probate process. It provides a sworn statement that identifies the heirs and their relationship to the deceased. This document is typically filed with the county recorder or land records office where the property is located. While it does not always transfer title immediately, it can serve as evidence of ownership over time. For instance, in Texas, an affidavit of heirship is primarily used for real property when someone dies without a will. It identifies the heirs and is filed in the deed records. Although it does not transfer title right away, after a certain period, such as 5 years, it can serve as evidence of ownership succession. On the other hand, Tennessee allows affidavits of heirship to establish property ownership for intestate estates. This can be a cost-effective alternative to probate. The affidavit must include detailed family history and relationships of the deceased to be valid. Some states do not recognize affidavits of heirship as a standalone document for transferring title. Instead, they may be part of the probate or estate administration process. In these cases, the affidavit helps prove the heir's rights but does not transfer property by itself. Additionally, several states have small estate affidavits or small estate administration procedures. These options allow heirs to inherit property without going through full probate if the estate is below a certain value. For example, in Texas, a small estate affidavit can transfer only the homestead to a surviving spouse or minor child, requiring court approval. In California, small estate affidavits are more common than affidavits of heirship. They are limited in scope and application, which can affect how heirs manage property after a death. Understanding these differences is vital for anyone involved in elder law or estate planning. Affidavits of heirship can simplify property transfers in intestate situations, saving time and money. However, because the rules vary, it is essential to consult with an attorney familiar with state-specific requirements. This includes knowing what information must be included, who can prepare and sign the affidavit, and how it impacts title transfer. In some areas, inaccuracies in the affidavit can lead to legal challenges. Therefore, knowing the distinction between affidavits of heirship and small estate affidavits is important for advising clients on the best methods to clear title or transfer property after death. Understanding the rules in your state can make a significant difference in how smoothly the estate planning and probate process goes.